right. Thank you for joining us today for Immigration 101, Options for Successfully and Legally Sponsoring Foreign Professional Workers in the U.S., part of APAC's Small Business Webinar Series. My name is Duke Nguyen Abrahamson. I am the Executive Director of the Asian Pacific American Chamber of Commerce, also known as APAC. This year, APAC celebrates 23 years of facilitating business relationships among business owners with Asian heritage and U.S.-based companies and promoting the economic advancement of the Asian American Pacific Islander. Businesses owned by Asian Americans with heritage from China, Japan, Korea, Taiwan, Vietnam, the Philippines, and India, among other countries, Fortune 500 corporations, entrepreneurs, business professionals, cultural organizations and associations, and political and government dignitaries have supported APAC throughout the years and are the reason for our success. We are a collaborative voice of 30+ Asian and Asian Pacific countries. We are able to do this through our strategic partnerships with Asian cultural associations throughout Michigan and nationally, and through our sponsors. Let me begin by introducing Laura Van Hoody, APAC Small Business Action Committee Chair. Laura is the Vice President of Employee Health and Benefits for Marsh & McLennan Agency. She has a drive and passion for implementing strategies that seek to help clarify the many confusing nuances of health insurance from consumer experience, as well as supporting the HR team by increasing engagement, simplifying processes, and creatively managing insurance expenses. Laura?
That's great. Thanks so much, Duke. I appreciate it. And thanks for everybody who is joining on this wonderful day. I have the privilege of leading as the Small Business Action Chair Committee within APAC. And really what we do is there's a small but mighty group of us who come alongside Asian businesses to not only understand their issues and receive clarity on what they're facing within our environment today, but also we get to partner with larger companies that have resources and knowledge and teams. And through that collaboration, we can then put on different events, webinars, and so forth. So I won't go too much into what we're looking at for next year. I will just do a little teaser that we are excited. We have some ideas in the workings, but for today, I have the privilege of really being able to introduce our speaker and our expert, Chris Allen. He is really a thought leader, an expert, an educator when it comes to immigration. And gosh, there are so many different changes that are happening. And so if you can really pay attention for the next hour and learn from him, I think you will find some great value. So with that being said, I'd love to introduce yourself, Chris.
Okay, thank you, Laura, and Duke, and APAC. Thanks for having me. I'll give a real quick bio of myself. My gray beard probably gives away my age. I've been doing nothing but immigration law for about 30 years now. Our firm, AMS Global Immigration, focuses primarily on business immigration law. We help companies with temporary and permanent work visa sponsorships and related compliance so that they can secure the top talent around the globe for the United States. In addition, I am very active in many HR communities around town. I was an adjunct professor of immigration law for about 15 years or so. And so it's been a passion of mine and a singular focus for my entire career. So I'm happy to talk to everybody today about the U.S. immigration law system and see if we can give you a little bit of guidance as an APAC member and either a small or medium or large size business about how the U.S. immigration system works and what some options might be available for you to supplement your U.S. workforce with some foreign workers. So with that, I'm going to share the PowerPoint deck here and make sure we get this going. There we go. Okay, so as Duke and Laura said, the topic today is options for successfully and legally sponsoring foreign professional workers in the U.S. And I just want to real quickly point out that word professional. Even though, as you can see by the graphic, we are The land of immigrants. We have the Statue of Liberty in the New York Harbor there. For a variety of mainly political reasons, our U.S. immigration system has historically drawn a line in the sand about which types of foreign workers we're going to allow to be sponsored to come to the U.S. and be employed here. And there are some exceptions. We have programs for seasonal farm workers, for other types of seasonal and temporary help workers. But by and large, what we're going to be talking about today are professional workers. And that in a nutshell means these are individuals who have a professional education, typically a 4-year bachelor's degree or higher, and they're coming to the United States with sponsorship from a company to be employed in a position which requires at least that degree. So again, there are some options for people who don't fit that exact profile. Notably, there's one that we'll talk about briefly under the USMCA or the old NAFTA treaty. But generally speaking, again, that's the threshold we're talking about. If you're interested in exploring options for other what we call skilled workers who possibly don't have that 4-year education, we'd have to talk about that separately. Now, having laid that foundation, another aspect of the U.S. immigration system that I think is not well known is its complexity. And I say not well known primarily to native-born U.S. citizens. When I give these presentations and there's U.S. citizens in the crowd or the audience, I often get the comment that, wow, I just had no idea that this is how our immigration system actually works. And I always have to tell them, yes, this is not what you think. We're going to talk about in a minute how the U.S. immigration law is structured and the government agencies are structured. It's very counterintuitive. It's not something you want to be dabbling in. We're also going to talk about some terminology. I don't want to get too pedantic about it. These are things that I used to teach my students for an entire class. But there's a running joke that if you put 2 immigration lawyers in a room, it's like they're speaking Greek, right? No one can understand a thing we're saying. There's a lot of terminology, a lot of slang, acronyms, a lot of, unfortunately, misused terms on the internet. So we'll talk about that a bit. Then we want to get into the various categories of foreign workers that you as an employer may be able to sponsor. And again, we're going to be focusing on professional workers, foreign students, because they are, by definition, when they graduate, a professional worker, and possibly a little bit about business visitors. There's going to be a lot to remember, but I will be able to provide this deck to you later as a reference if you would like to contact me after. And of course, APAC will have this video available for you to review as many times as you want, I assume. We are going to touch on green card sponsorships a little bit, just because ultimately that is the goal for a lot of your foreign workers who you employ. That could be an entire separate webinar, though, so we're just going to go over that briefly, give you a quick background so you can speak intelligently with a prospective foreign worker about what a green card is, why they want that, what you might be required to do in order to help them with that. And there are very critical timing issues that pop up with that, so also good to know. And finally, we can't do any immigration presentation without mentioning compliance. For employers, that mainly refers to the Form I-9 that you have to fill out as a U.S. company when you hire every single person in the United States, U.S. citizen or otherwise. The Form I-9 compliance system is also very complex, so we're going to touch on that briefly just to remind you that whether you are sponsoring lots of foreign workers or just one, you still have to have your I-9 ducks in a row and your house in order. Okay. Now, having said that, I alluded to this earlier, but this is a funny quote that I've been using for decades, literally. I used to use it with my students, the U.S. citizen students, because, again, they were just incredulous that this was how the law works. So I always remind people that a lot of what we're going to talk about here is counterintuitive. It is political. It doesn't make a lot of sense. Honestly, I'm not sure it was ever designed to make a lot of sense. But this is what we're stuck dealing with. You essentially have to understand some core elements here. And if we start there, everything else is going to make be a lot easier for you to actually implement as an employer. So again, without getting into too much detail, it's important to know that unlike many countries around the world, in the United States, we have one immigration law only. So now, if you're familiar at all with other areas of law in the U.S., there's local, state, federal level laws. There's a huge web of them. They often intertwine or conflict. The one odd thing about the U.S. immigration system is that it is federal, meaning it's exactly the same across the entire country. We have clients in every state in the country, pretty much, and with very minor exceptions, the process is identical for all of them. And that is because we're dealing with one immigration law. Unfortunately, that immigration law was originally written in the 1950s, was updated around 1990, and pretty much has not been touched ever since. So we are dealing with a very antiquated, out-of-date immigration system that is certainly not in line with modern business realities and the reality of the economy. But again, that's where we are. It's very political. We're not going to get into any of that here. Just suffice it to say that there's lots of great proposals in Congress to fix the U.S. immigration law and make it more business friendly. They never go anywhere. So not holding my breath on that one. So in the United States, we actually have 3 government agencies involved in implementing our one U.S. immigration law. And the reason this is important to know is because each of these agencies are legally separate. They each issue their own regulations explaining how they think this law was written and how they're going to implement it and provide immigration benefits to their customers. Each of these agencies doesn't really like the other one. They are not under the authority of the other one, so they will often conflict and overrule each other. A good example of that is in the middle, we have the Department of Homeland Security. This was, going to a little bit of history, this was the agency that was created after 9/11 when the old INS, or the Immigration and Naturalization Service, was broken up into several different agencies and all under the Homeland Security Department. So this agency has authority to accept, process, and approve or deny company sponsorship petitions. They also have authority for foreign workers who are physically inside of the United States. The USCIS does. But there are several other sub-agencies within the Homeland Security Department that have different functions. The US CBP agency, for example, has authority at the border. And the US ICE agency is sort of the immigration cops. They do the enforcement, but they're involved with foreign students. So again, you end up dealing with multiple different agencies within the Homeland Security Department, and it's important to know which one are you working with in order to figure out how do they feel that this benefit should be applied for properly. Now, we also have the State Department, kind of going back to number 1 on the side. Keep in mind that all of our U.S. consulates and embassies around the world outside of the United States are actually not under the control of the immigration agency, the USCIS. They're under the control of the State Department. The State Department, again, has exclusive authority over them, and the State Department issues what we call visas. We're going to talk about a little bit here the difference between a visa and a petition or status. Unlike in many countries of the world, in the United States, when somebody applies for a visa at a U.S. embassy abroad, it's essentially just an anti-terrorism and criminal background check and authority to get on a plane. A visa in the U.S. law doesn't guarantee entry to the United States and doesn't actually say how long someone can stay or what they can do or who they can work for. Once they hit the border, again, they end up under the jurisdiction of this separate Homeland Security Department. And those people decide, are you going to get in? How long can you stay? Has your employer sponsored you for work authorization, etc.? So again, kind of a disjointed system. To make it even more fun, we have the Labor Department. They're responsible for protecting the lives and careers of U.S. workers, and they have a little bit of a hand in a couple of immigration processes. So that's the way your government actually works. Again, it couldn't be more confusing if you designed it to be confusing, but that's what we're dealing with, so it's important to know, at least briefly. Okay, now having said all that, let's say you are a foreign company setting up shop in the U.S., or you've already established a company here and you have identified one or more foreign workers that you want to employ, what are your options? Initially, we're going to talk about what are called non-immigrant workers. These, again, focusing primarily on the professional workers. Non-immigrant workers simply refers to the fact that these are people who are here temporarily. They are not intending to live in the United States long term. For many of our non-immigrant visa categories in the U.S. law, it's a requirement for the individual to convince the U.S. government that they will not try to stay in the U.S. long term, that they promise they'll go home immediately after they take their vacation or finish their education as a foreign student or whatever it is they're doing. So these are temporary workers. Again, we can talk about permanent immigrant or green card sponsorship a little bit later. So here's some of the most common types of non-immigrant workers that you could run into and some tips and tricks for how you might be able to employ them. The first one I'm going to talk about is foreign students. These are obviously non-U.S. citizens, primarily in graduate level education programs in the U.S., although undergraduate students are eligible to come over as F1 foreign students as well. In the past, we used to have a lot of high school students coming in as F1 foreign students, but not so much anymore, merely because after 9/11, that was all locked down. It's pretty much university students only. So they have to be sponsored by their school. So the school essentially intervenes initially in their immigration process, I'll say. And the school will tightly control what foreign students are allowed to come in. They keep track of the fact that they're going to class. Again, after 9/11, the US ICE agency is involved in enforcing all of this. So where they're going to come onto your radar is either before graduation or after graduation. F1 foreign students have what we call practical training opportunities. And that is an old provision in the US law that says if someone comes here and pays all this money for out-of-state tuition to get a coveted US degree, they should be allowed to remain in the US for a little bit longer after graduation, get some practical hands-on experience or training, and then take all of that education and training back home to have an illustrious career in their home country. Again, these are non-immigrants. These F1 students have to convince the U.S. visa officer at the consulate when they first came over that they promised they will not stay in the U.S. We'll see why in a minute that's important. So there's two types of practical training that are available, CPT and OPT. Again, a lot of acronyms. I'm going to apologize for that again, but there's just no way around them. CPT stands for curricular practical training. OPT stands for optional practical training. The differences are this. CPT is typically before graduation. So if you are familiar with the U.S. education system, we have a lot of U.S. Kids who will do what we call co-op. They will go to work for 3 months, come back and go to school for 3 months, go back to work. They kind of go back and forth. And it's part of their degree program that they get out into the workforce with the company and get some actual internship or training. So F1 foreign students can do the same. The nice thing about that is it's super simple for you as an employer. It doesn't require any filing by you with immigration. It doesn't require any sponsorship, zero costs. The school and the student handle it entirely on their own. The problem with this is it's always very short term. It's by definition for the duration of a semester. So it works great for internships, even sometimes summer internships can be CPT, but not a good sort of mid or long-term employment option. But it's a great way to get someone on board. And if you have open internships, keep in mind that these F1 students can do it. I talk to companies all the time who will just say, we're not interested in talking to any foreign students. And I tell them, that's a mistake, right? You're missing out on an enormous amount of talent. You go to any good engineering school here in Southeast Michigan, in their graduate program, there's no US kids in those programs. It's all foreign students. So these are some sharp kids that could be an asset to your organization. After graduation, though, it becomes a little more standardized. We have this OPT, or optional practical training, kick in. And the basic rules are for 1 year after graduation, these foreign students are allowed to work full-time for any company in the US with very little to no sponsorship from you as an employer at all, as long as the job they're doing is directly related to their degree program. So they don't just get unlimited work authorization to go out and work at a gas station or something. It really has to be something professional related to their degree. And if they have been studying in a STEM field, meaning science, technology, engineering, or management, so a scientific or engineering degree program, they are most likely going to be eligible for an additional 2 years beyond that first year. That requires a little bit of company interaction or sponsorship. There's what we call a Form I-983 training plan that you'll have to sign off on to explain to their school what exactly it is that they'll be doing and why that's related to their program, what they're going to learn. But again, in a nutshell, if you come across these foreign students, you can get, especially in a technical or engineering field, you can get up to 3 full years of pretty flexible work authorization without a lot of immigration sponsorship or cost. Now, that's obviously not permanent. We can look at other visa options and green card sponsorship for more long-term employment, but this is a pretty good deal for most small businesses if you're struggling to find workers, as many are, despite the economy. So the next one I'm going to talk about is H-1B professional workers. This is kind of our catch-all visa category for professional workers in the United States. It again was designed in 1990 and unfortunately hasn't really been updated. So it's got some quirks, it's got some challenges, but this is the type of temporary work visa that companies use to sponsor most professional workers who come to the United States or are already here. A lot of F1 students, when they're butting up against that second or third year of practical training work authorization, they're going to be looking to their company to sponsor them for this H-1B professional worker category so they can stick around longer and continue working. Again, this is professional, so we're looking at degree-holding individuals doing jobs which require that degree. That in the H-1B world, that's what we call a specialty occupation. And it's very important that you have that job offer and educational background or degree match. One of the biggest challenges we have with this H-1B category right now is that because it was created in 1990, there is a limited number of these available to people getting into that classification for the first time every year. We won't go into all the details about how that works, but suffice it to say that because that cap or quota was created in the 90s and we are in the year 2023, the demand for these workers far outstrips the number of H-1B visa slots available every year. And believe it or not, the U.S. Immigration Service conducts a random lottery every March to decide which lucky companies are going to get their H-1B workers the following October 1st. October 1st is just the beginning of the government's fiscal year. This past year, the odds were pretty dismal in that lottery. It was about 15 to 16% chance of winning. And I mention that only because that ties back to this F1 foreign student practical training thing. If you have an F1 student who's got this practical training and working for you, you're probably going to want to run their name through that lottery every chance you can, every March that you've got, because the odds of winning are fairly slim right now. We're hoping that Congress will expand that quota of H-1B workers in the U.S. The economy certainly justifies that, but again, that's politics, folks. Now, assuming that you do get lucky in the lottery and your employee's name is selected, there are a couple of other quirks to be aware of. This is one place where the Department of Labor gets involved with what we call a labor condition application. And believe it or not, you have to post a notice to your other U.S. workers that says, we are about to hire a foreign worker in this job at this location for this amount of money. And that's a little bit awkward for small businesses and anathema for HR managers. But unfortunately, it is required. It's also important to know that H-1B sponsorships, when they're approved, it is a company-specific sponsorship. So this is obviously a very personal thing to the individual. They have, they're personally invested in that sponsorship and approval, but it is company-owned, and it is specific to not only the company, but the particular job and the particular work site. So you have to be very careful when you have an H-1B worker on board. If any element of their employment changes, you need to stop, talk to your immigration lawyer, and look at whether you need to notify the government before that change actually happens. As you can probably imagine, this was a bit of a nightmare during COVID because everybody went home and no H-1B workers were authorized to work at home at that time. So there was a lot of scrambling to stay in compliance with the H-1B workforce. I won't, again, get too pedantic about the terminology, but this is one area, this specific area, H-1B workers moving or changing jobs, or even changing employers. And this is one area where a particular slang term has just always really rubbed me the wrong way, and that's the word transfer. So in reality, nothing in the US immigration system ever transfers. You won't see that word used anywhere in the law, the regulations, immigration forms, in any sort of substantive way. And the reason for that, again, is because H-1B sponsorships are specific to a company, a job, and a work site. They sort of have little to do with the individual themselves. So when an H-1B worker changes companies, nothing is going to just transfer to the new company. Their prior sponsorship just is immediately voided. It's legally irrelevant. The new company steps up and redoes the entire sponsorship process exactly like every prior employer has in the past for that worker. Now, the nice thing is H-1B workers only go through the lottery once. So if you come across an H-1B worker with another company that you want to hire, you won't have to worry about this silly lottery thing. But again, it is an investment. You will have to go through and file all the same sponsorship paperwork with the Labor Department and the U.S. Immigration Service, the USCIS, and all the same obligations apply. So keep that in mind. Okay, another category, I mentioned it briefly earlier, there is what we call TN professional workers. The TN category was created by the NAFTA treaty. Nobody's quite sure why they called them TNs, Treaty NAFTA, instead of NAFTA treaty visas. But in any event, they've been TNs ever since the early 1990s, and we're stuck with that. It's now as you probably know, the USMCA treaty, not the NAFTA treaty. The nice thing about the TN work visa category is it's very similar to the H-1B category in the sense that with only a few exceptions, this requires that you're hiring somebody with a degree for a professional job, which requires that degree. But the differences are, one, this is limited exclusively to full Canadian or Mexican citizens, right? This is based on a diplomatic treaty that we have with those two countries. So only these three countries get to benefit from that treaty. However, it does not require a lot of the sponsorship filings and costs and paperwork that an H-1B sponsorship does. So it's a great way to get somebody on board very quickly, very cheaply, and the only caveats being, again, there is a limited list of occupations which qualify for this type of visa, and the individual, of course, again, has to have that appropriate background. A couple of odd quirks with that limited list of occupations that are available for the TN workers. There is one that we call scientific technicians, technologists. So this is one of the areas where we can possibly squeak in some more technical people who are not degree holders. Again, we could do a whole other class about what that means, so I'm not going to get into the details of that. But suffice it to say, if you have somebody with, let's say, a 2-year engineering technology degree from one of the many good trade schools up in Canada, that doesn't necessarily mean we can't do a TN work visa for them. We just have to be a little careful and explore that very closely. Another quirk, most higher level jobs do not qualify for this. So as soon as somebody hits the level of being a manager, we most likely are going to have to get them into that H-1B category. That the TN category is probably not going to work. These are valid for up to 3 years. So again, a nice, quick, cheap way to get somebody on board and working for you, a professional worker, for up to 3 full years. They can be extended in theory indefinitely, although keep in mind they are non-immigrants. So you have to watch if you have somebody in TN status working for you for 6, 7, 8, 9 years, they're eventually going to hit a point where the immigration officers are not going to believe this is a temporary job and they're a non-immigrant. They have to be a little careful about that longevity. But again, nice way to get them on board initially. Finally, one other quirk, we have an arrangement with Canada that is slightly different than Mexico in the US immigration law. And that is Canadians are actually what we call visa exempt. So contrary to, again, popular rumors and slang terminology, Canadians never get visas. They show up at the border and they're admitted into the United States directly with immigration status. They don't have to go to the US Embassy in order to get a visa like most other people around the world do. That's not true for Mexican citizens, though. So Mexican citizens are going to have to apply for a TN visa at the US consulate in Mexico before they can come up. The reason that's important is showing up at the border as a Canadian citizen, as long as all of the proper sponsorship paperwork and packages in their hands, that's quick, right? You can get in and out of the Detroit-Windsor Tunnel here processing one of these TNs in less than an hour, and you are immediately authorized to work for 3 years. A Mexican citizen, though, getting an appointment at the US consulate down in Mexico, applying for that visa, and then getting on the plane, that can take several months, depending on the backlogs of the appointment calendars at the particular consulate down in Mexico nearest you. So for the Mexican citizens, a little more advanced planning is going to be needed. But again, great option to keep in mind. Okay, a few more options. There's, as I mentioned here in the slide, we like to call it the alphabet soup of U.S. work visas. And I should probably point out that each of the temporary work visa categories in the U.S. law, they're typically designated by a letter, followed sometimes by numbers and additional letters. That's not anything to do with the type of worker authorized under that visa. It's merely a section of the immigration law. So there's nothing magic about it. The H-1B workers are just section H-1-B of the law. That's it. So there's a few others here that I want to point out. There's actually about 30 some odd total, but these again are the most common. So we do have what are called L1 global intracompany transferees. So if you are a multinational organization, meaning you have operations in at least 2 or 3 countries around the world, one of which is the United States, or you're coming to set one up in the United States, you may be able to transfer your high-level executives and managers and even some highly specialized technical workers into the United States from your operations abroad. So this visa requires that you are taking somebody who has been working for you outside the United States already for at least 1 year in the past 3 years. And for whatever reason, they are a highly coveted executive or manager, or they are a very skilled individual who has assets, training, knowledge that's just not readily available in the United States. We can use these L1 visas to transfer them in to the United States to work for you here. And this is nice because it doesn't involve any lottery. There's no cap or quota or limit on these. So you can do these all year long. There's some flexibility on payroll. Because the Labor Department is involved in H-1B visas, those sponsorships require that you put the individual employee on your U.S. payroll. The Labor Department will be watching tax payments and whatnot. In the L1 context, you can keep somebody on foreign payroll, and that's generally speaking okay as long as they're actually employed here and working and you're reporting to a manager here. So you've got some additional flexibility there. These visas also, at least at the L1-A manager level, can be valid for up to 7 years. It's only 5 years on the L1B technical workers, but still that's a decent amount of time. And there are 2 types of temporary visas in the U.S. system that allow someone to work in the U.S. while they simultaneously try to get sponsored for a green card in the background. The H-1B category is one. This L visa is the other one. So very flexible to transfer an employee in. If after a couple of years it looks like they're working out, you can do green card sponsorship, and you may not have to switch them over to the H-1B category at all. Next, we have E2 treaty investors. There's also what we call an E1 treaty trader. So these visas are very common for many companies in the United States, and also very common for startups. The idea is that the United States has what we call treaties of friendship, commerce, and navigation with with a lot of countries around the world. There's more than 25 or 30 of them, these treaties in place, and there's more being added all the time. Whenever the U.S. strikes one of these treaties with a foreign country, they typically will slip a little immigration provision right at the end that says, by the way, your citizens of your country are now eligible to apply for E2 visas or E1 and E2 visas to come to the United States and work. And the idea is that if a U.S. company is trading heavily with the United States or is going to invest a significant amount of money in the United States to either start a business, expand a business, that sort of justifies the underlying concept of these business treaties and allows you then to sponsor E2 or E1 workers to come in and support that U.S. investment or U.S. trade. Now, again, a couple quirks on this. It's great that there's no quotas or limits on these either. They can be done at any time during the year, all year long. But they do require that you register the U.S. company and the kind of group overall with the U.S. company, a U.S. consulate in the home country. So the U.S. consulate is going to be looking at, are you really a multinational organization? Are you all owned by the same people? Are those people citizens of the country where the U.S. has struck the treaty? Right. Again, this is a treaty-based thing, so this is only available for citizens of that country. So that requires a lot of documentation about ownership, finances, business plans, etc. But once you have the company registered, that's typically going to suffice for a couple of years at many places around, many consulates around the world, and then you're allowed to look at bringing over individual workers. Keep in mind, though, again, we're talking about citizens, so the individual worker's citizenship has to also match the country where we have the treaty. So the company ownership and the employees all match. This is a treaty-based visa. But again, when it's available, when the facts line up, this is a great option to use because, again, we can do it all year long. There's quite a bit of flexibility. There is what I like to call a quasi ability to sponsor a green card for somebody who's here as an E2 employee. We just have to be a little bit careful about the timing. It's not quite as flexible as the H or L workers, but again, a great way to bring in some talent, especially if you've got people abroad who you really need to get in here to support a new startup, a new sales organization, launch of a new product, whatever it is. And lastly, for the non-immigrant workers, I'm going to mention business visitors. The reason I put this on here is because business visitors are not actually a work visa, but that is very commonly misunderstood and misused, I'm going to say. We like to kind of joke in my world that contrary to everything you hear on the media, all immigration lawyers know the number one most abused section of the U.S. immigration law is business visitors coming into the United States and doing all sorts of things that look a lot like hands-on work, and they have not applied for or been sponsored for the correct work visa. So keep that in mind, that it is possible to come as a business visitor for meetings, to get some training, to go to a conference. It is not a work visa. So unlike during COVID, when we had a lot of these Caribbean countries pop up and say, hey, come on down into our country and just live here during COVID. You can work, you can do anything you want. That is not how the U.S. business visitor category works. Now, there is a huge body of court cases and policy documents and just history of adjudication about what the word work means. So as I mentioned here, every country defines it differently. In the U.S., we're somewhat restrictive on how we define that word. I always tell people the easiest way to think about this is if you want to have someone come into the United States as a business visitor, and this is, I probably should have mentioned, this is what we call the B-1 visa category. If they are coming here to do something which any U.S. citizen might get paid to do, you most likely have a problem. You should stop and start talking to your immigration lawyer about actual work visas. People get away with doing that a lot for a very long time, but when they get caught, it can become very nasty. And another twist that we've seen in the past 5 or so years, much more often than in prior decades, was keep in mind that if you bring somebody into the United States as a business visitor, even not considering are they working illegally and should have had a work visa, merely the fact that they're merely here for a certain number of days can trigger local tax and labor laws or employment laws. So that's all outside of my field of expertise. We have partners that we'll bring in to help our clients with those issues. But keep in mind that aside from the immigration issues, bringing people in on B1 business visitor visas in any sort of long, even mid to long-term capacity can trigger a lot of other legal problems. And this is true in foreign countries as well. You can't just take an employee and plop them up in Canada for 6-9 months a year and let them work remotely. You're probably triggering Canadian tax law and employment law issues for your US company. Okay, but it is a good, great option if you need someone to just pop in, quickly support a project, have a meeting on a project that's cross-border. The B1 business visitor category is available. Okay, so how about immigrant workers? The U.S. immigrant sponsorship laws are, again, fairly complex. I think I mentioned we could do an entire webinar or class on this topic alone. Suffice it to say that the law is split kind of down the middle into two types of immigrants. We have an employment-based side of our law and a family sponsorship-based side of our law. I'm not going to go into the family sponsorship side at all during this presentation. We at AMS Global do handle a significant number of family-based cases for our clients, both things that come out of a relationship with a company, as well as just individuals who want support. Maybe they married a U.S. citizen, or they've been here with the green card for a while and they want to apply for naturalization or citizenship. But on the employment-based side, the biggest challenge we have is, again, our 1990 law. So back in 1990, about 10 to 12 different categories of employment-based green card types were established, and they really, again, have not been changed ever since. And there were limits put on the total number of green cards in each category that can be given out each fiscal year back in 1990, and those have never been changed. So they are static. So for many of these categories, almost immediately after 1990, a backlog developed. And that causes people to wait certain people to wait a very long time before they actually get a green card in hand. We're going to talk about a couple of specific instances of how that works in just a minute. But some of these lines can be very, very long. But on the employment-based side, most green card sponsorship starts with what we call perm labor certification. So as a general rule, again, we're talking primarily professional workers here. And as a general rule, in order for a U.S. company to sponsor somebody for permanent residence in the United States, the term green card is just a slang term for permanent residence. So they can, when someone has this status, they can live and work here indefinitely for life. That process typically starts with labor certification with the Department of Labor. And it requires that the U.S. company go into the local labor market with a very specific job description or profile and prove that there were no fully qualified U.S. citizens who were available and willing to take that job. So that's kind of a fundamental threshold that you didn't hear me talk about much in any of those temporary work visas. The reason being a non-immigrant visa is by definition a temporary need, whereas this is going to be a long-term need. So you're going to have to explain to the Labor Department, why am I unable to find U.S. workers? Why is the job so complex, the requirements so high level that I just can't find U.S. workers? I need to keep this foreign worker permanently. That's called perm labor certification. Right now, the Labor Department has not recovered from COVID backlogs on their processing of these applications. This step in green card sponsorship alone now can take sometimes up to 2 years. So it's a very long-term thing. If you have a temporary foreign worker you're going to do this for, you really have to be thinking about this several years in advance of when they hit those limits on, let's say, their H-1B or L-1B temporary work visa. Now, once you get by that perm labor certification, there's actually 2 more steps with the Immigration Service, the USCIS, in the process. The first one, or it's really the second step in the process, but the first one with USCIS is relatively straightforward. It's what we call an I-140 immigrant petition. And I won't go into detail about that, but it's essentially just you as an employer going to the immigration agency and saying, I've got the Labor Department's blessing. There's clearly a shortage of workers. I can't find anybody. And I want to file a petition to directly sponsor this foreign worker now for permanent residence to keep them long term. Again, fairly straightforward filing. Approval rates are very, very high, assuming you get the Department of Labor blessing on the labor shortage. But at that second step, the focus then shifts off of the company a bit and onto the employee personally. There's a third and final application that most people will file in the United States, essentially going to the immigration agency and saying, my company has secured both sponsorship approvals. I'm eligible for a green card, and I want to convert, or what we call adjust, my temporary visa status to permanent residence or a green card. Now, the trick here with these backlogs and lines and that process is if your employer hits that second step in the process and there is a backlog in the particular category of green card that you're being sponsored for, you're going to be barred from filing that third and final step until you get to the front of the line. Now, without going into too much of the math around it, suffice it to say that these quotas or limits on green card numbers in each category in each year have a little bit of a twist on them, a little rule that says any one country can't sweep in and take all of the green cards of that category in any one year. So when a particular country has high levels of immigration to the US, they get subject to a backlog that is separated out from the rest of the world and can be significantly longer. Most often, right now, we actually have some backlogs for almost every country of the world. Some of them not so bad, a year or so, and it takes 2 years to get the perm approval, so you're probably fine. But if you were born in India and China, the backlogs for people from those two countries in these employment-based green card categories can be extremely long. I just had the unfortunate requirement to tell an employee just yesterday who is from India that if you're starting the process now, in theory, you're probably looking at about 10 to 15 years before you're going to get a green card. Now, this assumes that Congress doesn't change the law, doesn't fix this mess, and we're all hoping one day they do, but it can be a very long time. So keep that in mind. You need to start the process early, not only because the Department of Labor is very slow in processing, but also because if you have an employee from one of those two countries, especially, you're probably just getting them into a line that's going to take a very long time to reach the front of. Now, luckily, a law was changed a couple of decades ago by President Clinton, believe it or not, that said, if you are stuck in that line, you can get into H-1B status and continue to extend that beyond the normal 6-year limit as long as it takes to get to the front of the line. So it doesn't necessarily mean that you're going to lose this employee if they're from those countries and you're sponsoring them for a green card. Again, the trick's going to be get them into that line, continue to extend their H-1B status every 3 years typically until they get to the front, and eventually they will get to file that final application and get a green card. Now, only a couple of years ago, we had a nice change in the law that allows spouses of H-1B workers stuck in those backlogs to work in the U.S. Because as you can imagine, if you are a professional, educated spouse who came to the United States with an H-1B worker, and you're told 15 years until you get a green card and you can't work until you do, that was a pretty nasty situation. So this was a nice addition to the law. And is another opportunity for you as an employer to possibly hire someone without any immigration sponsorship or costs. So if you come across one of these, what we call H-4 spouses, you may have an easy hire. As I mentioned, the H-1B extensions are available beyond the 6 years if you are stuck in this backlog. But keep in mind, no transfers. So if you have an employee that you sponsored and you start moving them into significantly different roles within your company, or you move them to another location in the United States, you may have to just start over and get a new perm labor certification for that job and that location. And the same thing when these employees change companies. There's some flexibility in the law, what we call green card portability, for somebody waiting in those lines to possibly change employers. But the new employer is going to have to do their own green card sponsorship, because anything the prior company did does not transfer to the new company. Luckily, that employee gets to keep their place in the backlog queue, though, so there is some advantage for them. Okay, lastly, just some quick notes about compliance. This is probably more for your HR folks, but even as a small business owner or a small business executive, things you want to keep in mind. As I mentioned earlier, I-9s are required. Every time you hire anybody in the United States, you have 72 hours to get that I-9 done. It's technically how they count the 72 hours means 4 days, but it's always safe to think of it as 3 days. The fines for not complying with that rule in the event of an audit are ridiculous. So keep in mind also that when you do an I-9, if it's for a temporary or non-immigrant worker, there's going to be an expiration, and you're going to have to re-verify that person to make sure they have extended work authorization in the United States. And if you're using the government's e-verify system, I always tell my clients that is not an I-9 expiration tracker. Do not rely on that system. The e-verify system has a very particular use. It's sort of a quality control check on your initial I-9, but it is not your primary I-9 compliance system. Watch out for COVID effects. We are still sort of reeling from those right now. I'm not going to go into a lot of detail about those. I actually have a blog post on our website and on LinkedIn about this topic. But I-9s got very odd during COVID. They should by now all be fixed and normalized. If not, you definitely need to speak to someone because you've got a problem. Job postings have become an issue lately. So make sure when you are out posting jobs on the internet, you're not accidentally implying that you are discriminating against certain types of workers, not only just US workers. I've seen job postings that will say things like, we only want US citizens and green card holders. Well, if there isn't a government national security reason behind that you can prove, that is actually a violation of the US immigration law, and you can get into a lot of trouble doing a job posting like that. Lastly, keep in mind, who is the immigration attorney and who do they represent? We, again, primarily represent companies. We are your lawyer. We are not the employee's lawyer. And even if you're a small business who doesn't do this a lot, you do not want to let your foreign worker pick your immigration lawyer. You know, as you probably saw in a lot of the other things we talked about here today, there are formal government filings, there are compliance, there's actually compliance audit files that you'll have to maintain as a company doing these sponsorships. You want an attorney that you have hired, you are paying, and is working for you. And finally, don't call us last. You know, there's a running joke in my world that I am the very last person to know about the foreign worker who is about to get hired, second only to the HR manager, who is now in a complete drop dead panic. So call us first, and we're best way to help. And that's it for the basic presentation there. Did you guys have any questions at all? I know this is a lot of information to digest, right?
Yes, Chris, thank you so much. I do have a question, and it's more of your opinion. So although only 7% of Michigan's population are immigrants, the last 30 plus years, the only time Michigan has experienced a population growth has been due to immigration. I know that many other states are experiencing this as well. And as our aging population starts to retire, do you think the immigration law will start to change? I mean, it's been since 1990.
Yeah, that's a great question, and it's a little bit of a, I tend to jump up on a soapbox very easily on this topic, honestly. And the reason for that is the demographics are crystal clear, right? The baby boomers are retiring, they're going away. The New York Times and the Economist had some great articles out on this recently, and even if every one in the generation in their 20s started having 2 and 3 babies right now, it would not fix this problem. The global community knows the one and only way to fix this problem is immigration. So you have to inject more workers. Japan, for instance, has a horrible problem with this right now. China's experiencing it, right? The one-child policy has backfired a bit. Now they've got a shortage of professional workers. We are going to hit that wall here very soon. The problem is immigration is so political, right? So I always joke, there's great proposals in Congress to fix all of these problems, logical ones. Canada has no problem with these issues. They have a very flexible immigration system. In our country, every time somebody in Congress proposes something reasonable on immigration, somebody else stands up and screams 14 million Mexican rapists, and that's the end of it, right? It just goes off a cliff, nothing gets done. I am hopeful that this demographics problem will force the issue, force our politicians to actually do something business friendly. But I tell my clients, again, do not hold your breath on that. Figure out your path within the current immigration system and its limitations and quirks, because we're probably stuck there for a while.
Yeah, I know that APAC was part of a roundtable discussion with the Fed and the state of Michigan in regards to how we can, as a state and small businesses, start to attract immigrants to Michigan and to the the labor shortage that we're experiencing here in Michigan, and what we could do as small businesses, as APAC, or as even the large businesses. How can we attract immigrants to Michigan? Because Michigan, we're in competition not only with other countries, but we're in competition with other states as well. So, there's always that constant need for the new workforce.
Yeah. And I hope it's appropriate to do this here, but I'm going to give a little bit of a plug for another organization called Global Detroit, which is specifically focused on that issue, and they do some great work. They recently got a fairly significant amount of money from a government grant to help promote that. Again, it's kind of an issue near and dear to my heart, not necessarily what I do every day, but again, I can see that cliff looming. All my corporate clients can, right? They're, even with the economy kind of a little bit up and down this year, they're in certain sectors, the labor market shortages are just severe. So again, that's definitely, I think, a focus to keep the pressure on Congress. But again, just don't hold your breath. For 30 years, I've been saying, oh, of course they're going to fix this, right? This is absurd. Nobody ever does.
Global Detroit and Steve are great to know and to definitely get in contact with.
Yeah.
Thank you, Chris. And thank you, everyone, for joining us for the Immigration 101, part of APAC's Small Business Webinar Series. Thank you to General Motors for supporting the AAPI Small Business Community. And for these small business webinar videos, check out our playlist. More information about APAC, the Small Business Action Committee, and Chris, our speaker, will be located in the description below. Please leave a comment on what you would like the small business webinar to cover next, or what your small business needs. Thank you, everyone.